Google built one of the most useful products in modern business. The antitrust question, however, was not whether Google search was good. It was whether Google used contracts and payments to keep rivals from reaching users at the moment a search engine is chosen. In 2024, a federal court concluded that Google held monopoly power in general search services and unlawfully maintained that power through exclusive distribution agreements. This presentation asks a broader business question. When a profitable strategy is legal-looking, familiar, and effective, what ethical limits should leadership apply before a court intervenes? I will explain the conduct, the court's reasoning, Google's response, the final remedies, and what other organizations should learn from the case. Before looking at the legal details, this presentation focuses on one central question. Did Google protect its leadership mainly by offering the best search product, or did it also rely on contracts that made meaningful competition less likely? We will first examine how the default search strategy worked. Next, we will evaluate Google's response through legal, financial, and ethical lenses. Finally, we will consider whether the court's remedies are sufficient and identify practical lessons for business leaders. My thesis is that Google created genuine consumer value, but the exclusionary structure supporting its profits made the strategy ethically and legally fragile. The easiest way to understand the case is through three linked findings. First, the court found monopoly power in general search services. The opinion reported that Google received almost 90% of general search queries in the United States in 2020 and approximately 95% on mobile devices. Second, Google protected that position through distribution agreements. It paid browser developers, device manufacturers, and wireless carriers to make Google the default search engine at important access points. Third, the court found that these defaults denied rivals the scale needed to compete effectively. Search quality improves with more queries, more user data, and more advertiser demand. By limiting rivals' access to those inputs, Google reinforced its advantage. The case therefore focused on maintenance of monopoly power, not on punishing Google for becoming successful. This diagram shows why defaults mattered economically. Default placement generated more searches created user interaction data, and more opportunities to sell search advertising. That revenue funded large distribution payments, helping Google preserve the same access points. At the same time, scale improved search quality and made the product more attractive. Each part of the system reinforced the others. The ethical problem is not the flywheel itself. Successful businesses routinely create reinforcing advantages. The problem arises when a dominant firm uses contractual control over distribution to keep capable competitors from obtaining the scale required to challenge it. Leadership should have recognized that a strategy can produce consumer convenience in the short term while narrowing consumer choice and innovation over the longer term. The case began in October 2022 when the Department of Justice and state attorneys general sued Google. A lengthy trial began in 2023. In August 2024, Judge Amit Mehta issued the liability opinion and found that Google violated Section 2 of the Sherman Act by maintaining monopolies in general search services and general search text advertising. The remedies phase followed in 2025. The court entered a final judgment on December 5, 2025. By 2026, the case had moved into implementation with a technical committee and continuing status reports overseeing compliance. That timeline matters because antitrust enforcement is slow. Business strategy can shape markets for years before a final remedy takes effect, which makes internal ethical governance more important than relying only on legal enforcement. The case exposes the gap between law, corporate values, and ethics. The legal test asks whether conduct unlawfully maintained monopoly power, but ethical leadership should ask more. Google publicly emphasizes innovation, helpful products, security, and long-term investment. Those values are credible only if the company also examines who is disadvantaged by its strategy. Users may appreciate a convenient default, yet rivals can lose distribution, advertisers can become dependent on one ecosystem, and innovation can slow when the market is difficult to enter. Ethical analysis therefore extends beyond current legality. Leaders should evaluate stakeholder effects, transparency, genuine consumer choice, and whether success depends on superior value or on blocking access. A strategy that passes legal review today may still create reputational, regulatory, and social risk tomorrow. Google's defense had three important themes. First, it argued that people use Google because the product is superior, not because defaults eliminate choice. Second, it emphasized growing competition from artificial intelligence and specialized platforms. Third, it warned that forced data sharing could create privacy and security risks. These arguments should not be dismissed. product quality and privacy matter. However, they did not fully answer the court's central concern. A superior product can still be protected by exclusionary contracts. Google's response was commercially rational because it defended a highly profitable distribution model. It was legally unsuccessful because the court found the contracts helped maintain monopoly power. It was ethically incomplete because it framed the issue mainly around Google and current users, while giving less weight to rivals, advertisers, future innovation, and the integrity of the competitive process. The final judgment chose targeted behavioral remedies instead of a breakup. Google is prohibited from entering or maintaining exclusive contracts tied to the distribution of Search, Chrome, Google Assistant, and Gemini. Qualified competitors can obtain access to certain search index and user interaction data. Google must also offer search results and search text ad syndication services, helping rivals compete before they have built comparable infrastructure. A technical committee monitors compliance and assists with enforcement. The court did not order Google to sell Chrome or Android. That choice reflects an effort to restore competitive pathways without destroying integrations that may benefit users. The strength of the remedy will depend less on its wording than on implementation, eligibility rules, pricing, privacy protections, data quality, and whether rivals can use the access in time to matter. Are the legal remedies sufficient? My conclusion is that they are necessary but not yet proven sufficient. The judgment attacks the foreclosure mechanism by limiting exclusivity and giving rivals access to data and syndication. It also avoids the disruption and uncertainty of a forced breakup. However, Google can retain significant economic advantages, brand recognition, infrastructure, and the ability to make some distribution payments. AI may create new competition, but it can also create another gateway that Google can bundle into its ecosystem. The ethical standard should therefore be outcome-based. Compliance is not enough if rivals receive access that is delayed, expensive, low quality, or unusable. The real measure is whether consumers gain durable alternatives and whether competitors can attract users, improve their products, and monetize at meaningful scale. Continued independent oversight is essential. The broader lesson is preventive governance. First, organizations should map the leverage points in their business model: defaults, bundling, proprietary data, platform rules, and partner dependencies. Second, leaders should distinguish winning through value from winning by blocking access. Third, stakeholder review should include not only current customers and shareholders, but also suppliers, rivals, advertisers, innovation, privacy, and public trust. Finally, boards should create escalation triggers for strategies used in highly concentrated markets. Large distribution contracts and exclusivity terms should receive independent antitrust and ethics review before renewal. The goal is not to avoid profit. It is to build profit that remains defensible when customers, competitors, regulators, and employees examine how it was earned. The strongest long-term strategy preserves both excellent products and genuine contestability. These are the principal sources used in the presentation. The court opinions and final judgment provide the legal findings and remedies. The Department of Justice materials provide the procedural timeline and implementation status. Google's public response and Alphabet's annual report help represent the company's position and business context.